arrest or detention case, if you go to trial and you're found guilty, it's habitual. You're looking at 25 to life. We can set it for trial. I'm not playing games and I'm not going to accept the disrespect. Good morning. Are you Victor Charles Campbell Jr.?
Yeah.
And Mr. Parker, will your client waive the formal reading of the indictment in each case?
We are.
And it looks like we are going in 21-36426 and 22-39050, correct?
There's also a dismissal in 3059.
All right, Mr. Campbell. In cause number 21-36426, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle, and that's from November 28th of 2020. The indictment further alleges that you were previously convicted of assault family violence, a third-degree felony, December 5th of 2014. And how do you plead to that charge? So to the charge.
The court began by asking the defendant how he wanted to respond to a charge connected to avoiding law enforcement using a vehicle in November 2020. The judge explained that the only options were guilty or not guilty, and made it clear the court needed a direct answer. The defendant replied that he wanted to plead no contest, saying his attorney had not fully reviewed the case details with him. The judge questioned that claim and reminded him that the court only accepts guilty or not guilty pleas in that situation. During the exchange, the defendant explained he had only recently arrived at the facility and had limited time to speak with his lawyer. The conversation then shifted toward discussing the details and seriousness of the case.
Yeah.
So, the nature of the crime, no cause number, and the magistrate, as far as the indictment, I never received one. And due to the fact of the nature of the charge of being from 2018, you have 5 years or 4 years to indict me to actually send that indictment.
Sir, the allegation.
That's why I'm pleading no contest.
I'm not going to
I'm
allow.
fine guilty. It's fine.
Here's the thing. I don't have to accept any plea agreement.
Yes, ma'am.
Okay. So you can, in that evading arrest or detention case, if you go to trial and you're found guilty, it's habitual. You're looking at 25 to life. We can set it for trial. I'm not playing games and I'm not going to accept the disrespect. If you want me to follow this agreement and go along with the plea agreement and you can go on, do your time and be done with it, then we can get that done. But you're not going to show disrespect while we're doing it to me. Do you understand?
Yes.
So if you want to go forward, we'll go forward. If not, we'll set it for trial. Mr. Smith will get ready very quickly and we'll get your case tried within a month. And it'll be habitual 25 to life. What do you want to do?
It's 18 years.
No, the plea agreement.
If you go to trial, listen to me. If you go to trial and you're found guilty and your prior convictions, stop talking over me. If you go to trial and you're found guilty and those prior felony convictions are true, then you're looking at habitual 25 to life. Today, there's an agreement for something different. I'm glad to accept that if that's what you want to do. But you're going to either accept responsibility and plead guilty or plead not guilty. Yeah. That's your choices. So let's go back then in cause number 21-36426. You're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from November 28th of 2020. How do you plead to that charge? Guilty or not guilty?
That's what I'm saying. He's saying assault family violence. The evading arrest is pleading guilty.
The courtroom discussion became tense as the judge reviewed the official case details with the defendant. The judge clarified that the charge involved avoiding law enforcement with a vehicle during an incident in November 2020, and carefully read the information from the indictment. When asked again how he wanted to respond to the charge, the defendant repeated that he wished to plead no contest. The judge immediately rejected that option and explained that the court would only accept a guilty or not guilty plea. The defendant appeared frustrated and questioned why his answer was not being accepted. The judge stayed firm, repeating that no contest was not an available option in that courtroom, and demanded a clear response instead.
You plead guilty or not guilty.
So if I'm telling you no content, what is that?
It's nothing, and it's nothing. You're not allowed. I can take a plea of no contest, or I cannot take a plea of no contest. That is up to the court. You're not legally entitled to plead no contest if there's a plea bargain. I'm telling you, if you want me to accept the plea agreement, you're going to plead guilty or not guilty. I've already told you that. I'm not going to tell you again. If I have to tell you again, guilty or not guilty.
I'm saying.
Period. I'm about to set your case for
that's
trial.
saying that I'm not. That's basically saying that I'm.
We're not going to argue the law.
I'm not, or I'm guilty.
We're not arguing
That's
the law.
basically just saying that I state that.
I'm not going to argue the law with
no
you.
Guilty. Just sign. Go ahead. That's guilty. Go ahead. That's what y'all want anyway.
Listen,
I'm cool, man. Just go ahead.
Well, you're not. You're really not being cool, and you're making me very frustrated.
Ma'am, I respect your call. Just go ahead and give me
nothing here.
Pleaded guilty. There you go.
So you plead guilty to evading arrest or detention with the use of a vehicle. Okay. The next count, the next paragraph that you're looking at says that you were previously convicted of assault family violence December 5th of 2014. Is that true or not true that you have that conviction on your record? Okay.
And that's not the same.
That's
case
okay.
As far as evading arrest, man. That's two different charges. So if you really want to be technical as far as being a habitual, that's called a repeated offender. But
exactly, and that's listen. So, Mr. Campbell,
that's
wow.
I thank you.
Do you want to come sit up here and be the judge? You're so smart.
I don't know. If you needed some help, ma'am, I wouldn't mind.
I feel like I might because I'm not understanding. Mr. Campbell, you're getting a deal to go on count one only, which makes you a repeat. I get that you've been through this before and you understand what's going on, but you're making this more difficult. If you go to trial, you could be habitual. Today, if we take this great plea agreement, it's repeat. I understand that. I've been doing this for 30 years. Okay? So, did you enter your plea of...
The judge continued the hearing by confirming that the defendant was entering his guilty plea willingly and without pressure from anyone. The defendant confirmed that the decision was his own. The court then moved to a second case involving allegations of tampering with evidence connected to an incident from November 2020. The judge explained that only one count was being considered and again asked for a clear plea. At first, the defendant mentioned no contest again, but then confirmed he was pleading guilty. The judge carefully repeated the required legal questions, explaining that the law required the court to confirm in every case that no one had pressured him into pleading guilty. The discussion then shifted to legal documents on a tablet that contained the defendant's signature. The judge asked whether he had reviewed those papers with his attorney before signing them.
Before you signed those, did you go over them with Mr. Parker? The documents on the tablet, y'all have that? And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving any right to appeal? Yes or no, please. Do you understand that?
I understand what we signed, the documents.
Okay. You have to answer out loud, yes or no, so that the record's clear that you understand, that I know you understand what you signed. Okay? I'm not trying to, doesn't have to be that difficult. Just get in, get your deal, and get out. You're making this way more difficult than it has to be. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest could result in your deportation? If you're not a U.S. citizen, could result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law.
So what this is,
I'm required to ask everyone that. Are you a U.S. citizen?
Yeah.
Okay. State tender's number one in each case.
Objection.
It's admitted in each case. Is there any evidence that Mr. Campbell is not competent?
No, you're not.
I just printed the wrong thing.
She asked me if I thought if there's evidence you weren't. I said no, there's not. He's confident.
I just printed the wrong stuff. Did I print both of the
Give him the
certifications?
thing on that. Sure.
Okay. All right, Mr. Campbell, I'm going to find in each of your cases that you, Mr. Campbell, pay attention to me for a second, please.
Oh, well, I ain't drinking.
Mr. Campbell, you ready?
Yeah.
In cause number 21-36426, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of evading arrest or detention with the use of a vehicle. Find that prior conviction true. Sentence you in accordance with your agreement to a term of 18 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
So can you say that on record?
I'm on the
Yes.
record.
No, I'm saying say that how long I've been in custody.
I don't know.
I've been
I don't have that
in custody
information.
5 years.
Okay, you'll get all the credit that you are entitled to get.
3
by law.
months.
And cause number 22-39050, also find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of tampering with physical evidence. Sentence you in accordance with your agreement to a term of 18 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These two cases will run concurrently, which means together at the same time and concurrently with any other sentence that you're currently serving. I have signed a dismissal as part of this agreement in cause number 22-39051. I'm handing you in both of your cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that written admonishment. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition or about how long it lasts, you can talk with your attorney. You can go back with the bailiff.
So do I get my papers for my time, sir?
Go back with the bailiff.
Is you gonna bring me my papers for my time,
They
sir?
have it at the jail.
Excuse me?
No, they have it at the jail. No. I told you.
You didn't tell me.
Why he wasn't that bad?
I mean, this one might be difficult, and Judge, this one's really gonna push you over the edge difficult.